Okay, it looks like we're getting people hooked up to the Zoom. Mr. Wolven, you're there.
Yes.
Do you have video capacity?
Yes.
Connect to the video where it says connect to video.
Thought I just did.
Ms. Schmidt, you're there?
Yep, I am connecting right now to the,
Yep, connect to video. Ms. Flannery?
Yes, yes, I'm connected, I believe.
Okay, but not to video yet. Do you
Yeah,
have a button that says,
I
okay,
believe so.
then Ms. Schmidt, you're not connected yet.
yeah, I clicked the button.
Okay, all right, we got you in, I'm so sorry. So Ms. Flannery, you're at a separate location than Mr. Wolven.
Correct.
And Mr. Ricards, do you say it Ricards?
Yes,
You're with Ms. Schmidt.
yes, Your Honor.
Okay, then we got everybody then. I'm Judge Sara Smolenski, and this is on file D20 C0229 SP. We talked about this case briefly back in August, and I think the date that I spoke to a few of you was in August for the first pretrial meeting, and it was Ms. Flannery when you appeared and you had not yet retained Mr. Wolven and you came in on your own. It was like the end of August, 28th or whatever, I don't know. We did a Zoom. Ms. Schmidt, you were representing Mr. Ricards, and Mr. Wolven, at that time, you weren't part of it yet. At that pretrial hearing, you told me, Ms. Flannery, that you were going to be getting Mr. Wolven. So you had already thought about it or were talking to him or whatever.
Correct.
We briefly discussed that this was a land contract type case, that you did get personal service on it, that you, Ms. Flannery, did agree that you owed some money, but you weren't clear how much money it was. You weren't prepared to agree to a certain amount or anything like that. I then set it for the next appointment was September 3rd, and we didn't get it resolved. We've set it for a couple of hearing dates. I think there were some adjournments. Could have been on our side, could have been somebody else, I don't know. But here we are, October 8th, and I got the brief that you filed, Mr. Wolven.
Yes.
I actually got it this morning. It came in this past week, but I didn't physically see it. It didn't catch up to the file until this morning. I did get a chance to see it. I know that at one point when you were involved, Mr. Wolven, perhaps the last time that we all were on Zoom, if I'm remembering it correctly, and really it's been foggy and there's been a lot of cases, so if I don't remember it exactly, you guys will tell me, but I'm pretty positive you went in a conference room or what we call a chat room, breakout room on Zoom. There was some continued discussions with Ms. Schmidt, the attorney for Mr. Ricards, and for you, Mr. Wolven, on behalf of Ms. Flannery. I was not part of those discussions, but they were discussions. I don't know how long they were. You guys would remember better than I, but it didn't finalize the case. It didn't resolve it. There wasn't an ultimate agreement, which is what brings us to today's date and a determination of whether we need to take testimony or not on this case. It's a bit unique, the type of case that we've got. On a number of levels, it's unique because obviously the defendant, whether you agree or not, I don't know, Mr. Ricards, there's been allegations that you guys were a couple for a period of time. that this contract on the land contract for the house in Sparta goes back to 2010, that the lawsuit was more recently started this year in April, kind of at the time when everything was kind of in the COVID delay, COVID shutdown, COVID problems. And so while the lawsuit was filed in April, brings us all the way back to October now, 6 months later, we're still talking about what we're going to do on the case. When Mr. Wolven filed his appearance and the trial brief, the argument from the defendant is, well, if Mr. Ricards for 10 years never asked Ms. Flannery to pay anything, never requested any payment, never filed any lawsuits, you know, their defense is, well, how can you still say it's a land contract when the allegations from the defense is that you gave her every reason to believe she wasn't going to have to pay it because she never did pay it. Parts of the brief are unclear to me, Mr. Wolven, and it could be a typographical error, but there's a portion of the brief that indicates that Ms. Flannery only moved into the property in April of 2020.
That's not
And-
correct at all. I don't
Right.
know what
So that's a
part of
type.
that brief. She has occupied it since before, or at least at April 29th of 2010.
Okay. Well,
And
the
yet-
brief says 2020, so it threw me for a loop, and I thought it had to be a typo, but I wasn't clear. So that basically, during that 10-year period from April of 2010 to when the lawsuit was filed in April of 2020, 10 years later, again, it's unclear to me totally, but Ms. Flannery never paid any monthly fees toward the land contract.
That's correct.
And Mr. Ricards can address this as well. I don't believe Ms. Flannery ever paid the taxes or the insurance,
That's
and
correct.
that Mr. Ricards paid all of that. Even though under the land contract, there may be some allegations that the vendee, Ms. Flannery, the person buying the land contract, would be responsible for those bills, those payments, those costs. But for a period of 10 years, if she's living at the house with the kids and he's not there, she's basically living at that house at no cost. So fast forward to today, Mr. Wolven tries to say, how can you say it's a land contract when you, Mr. Ricards, you gave her every belief to think that it wasn't going to be pursued? And then Ms. Schmidt's representing Mr. Ricards and just say, call it like it is. They're saying it's a land contract, while he may never has pursued it with her before, or she may have never paid anything. He decided in April of 2020 he was going to try to follow the land contract and call upon Ms. Flannery to pay it. Yet again, in the brief of the defendant, she agrees she owes some money. She tries to, it appears, Mr. Wolven, from your perspective, I think, get a credit. I don't know how many 92 months is, but just say short of 10 years, a credit toward payments, and yet the brief said there was never any monetary payments made. There were
Right.
never any monetary payments requested. But in the calculations that you and your client do, you're trying to get basically a credit, whether that's for services, whether that's for, I'm not clear what. In a way, the way your brief is written, you want to say the land contract is null and void, but on the flip side of it, you want it to be applied so she'll have 6 months to pay X amount, which is around $8,000, and she's allowed to keep the house, with the 92 months being the credit, or $31,000 in credit, or something like that. Is that basically it, Mr. Wolven?
That's pretty much it, Your Honor. It comes out to the same place.
Yeah.
Ours is that basically, he has forgiven, waived, stopped, whatever you want to call it.
I get that that's
each
your
month that he's
argument.
waiving it, so that we are
Uh-huh.
treating it as though those payments have been made.
Okay. I want you also to take a look at the last page of your brief. I had trouble understanding the last paragraph. I'm guessing you dictated this and somebody typed it.
I typed it. What did I do
You
wrong?
typed it yourself. Well, it's the last sentence of the brief in the conclusion that I don't understand words that are in there.
Yes.
Polaverin and coaxin. I don't understand those words. I tried to look them up. I thought it was a medication, and then I thought, if you're dictating it, you typed it wrong. You indicate on the last sentence.
Woven, palaverin, and coaxin. Are those the three words you're talking about?
Yeah.
Little Irish, Your Honor. The wooing, I think, is pretty explanatory.
Yeah, I didn't have a problem with that word. It's the next two words I'm not
The
clear on.
palaverin is the, what do I want to say? How do you say it? You're beautiful. I love you. I love the dress.
You can get me a definition to that word because I didn't find it. It was a city in some area.
I don't
And then
really.
what's coaxin?
Coaxin.
That's the word you're using, coaxin?
I hope that's coaxin.
Okay.
And coaxin.
All right, well, that was just an inquiry I had.
Bribing, coaxing, making promises. How else can you say it when you are admiring somebody?
Yeah, I didn't see it when I looked up the definition, so I didn't know if they were spelled wrong or what. And then also, when you indicate on the second page of your brief, as of October 2, 2020, no amount of cash monies has been paid by defendant to plaintiff. It's really, in talking about this land contract, it's never. Fair?
It's never.
It's not just as of October 2, 6 days ago. We're talking ever.
That's correct. As of
Okay.
that date, he hadn't paid anything.
That's fine. I just didn't understand how you wrote that because it didn't make sense to me because it wasn't as of October 2. It was as of the land contract being signed, which would have been April of 2010.
But continuing
Ms.
on
Schmidt.
for 10 years, no payment.
That's fine. I get it. I just think it was written improperly. Ms. Schmidt, tell me your thoughts as it relates to the defense's argument of this waiver of this, equitable estoppel.
Yeah.
What are your thoughts?
Well, he is not being honest with the court. There have been payments. We have proof of those payments. My client will testify that payments have been made. In fact, there was in the district court, in 2011, there was a lawsuit between the parties, and she made payment of $7,700 after that to settle that. In the land contract itself, on the last page, there is a paragraph in there that states that about it is expressly understood and agreed that time shall be deemed of the essence. However, failure of the seller to exercise any right upon default of the buyer shall not constitute a waiver of any rights and shall not prevent the seller from exercising any rights upon subsequent default.
And that provision is what paragraph under the land contract you're referring to?
Last page number 18.
Okay.
And they're not being truthful. There have been payments made. We're not saying there's never been any payments made. And
well, I haven't talked to Ms. Flannery directly, so she can respond to that as well. But I was referring to the trial brief prepared by Mr. Wolven, so I understand that. Suffice it to say, the last payment that would have been made, we're talking going back 8 or 9 years. True?
No, she made a payment. The last payment we've received was March 2000.
March what?
2014.
Okay, so 6 years.
Correct. And there were subsequent statements to her or letters to her about payment.
Okay.
They have made contact with her.
Do
She
you
doesn't-
know whether your client, Mr. Ricards, owned that property with anyone else at the time he signed the land contract?
No, it's just me, Your Honor.
Okay, so there's no other owner involved, it's just you?
Yes, correct.
Okay. All right, so do you want to take testimony on this at this point? I mean, the decision that I have to make is whether Ms. Flannery owes any money under this land contract, and if so, how much?
Yes, Your Honor, we're prepared to take testimony of my client.
Okay? Is there anything else that you can think of that you have a question about, Mr. Wolven, or how you want to address that paragraph 18 that says, even if he doesn't ask for the money, his rights under the seller's part of this land contract are not waived?
Well, I don't think so right now, Your Honor.
All right.
He's waived that provision.
Yeah,
You
that's
can't-
your
all of a
argument, I
sudden, the
get
man has an affair for a long period of time, and all of a sudden he's charitable, or I'm not sure what his reason is, but whatever it is, she has
Well,
been
I'm
with
assuming their
the police.
relationship no longer exists in the
That's
way
correct.
that it did.
That's
Yeah, well, that
correct.
would pretty much be indicative of how, it's like a marriage with no divorce, or a divorce with no marriage, except that he's married to somebody else, if he is, or was. All right, let's take testimony then. Are you starting, Ms. Schmidt, with who?
Mr. Ricards.
Okay, Mr. Ricards, I'll ask you to raise your right hand. You do solemnly swear you'll tell the truth, the whole truth, and nothing but the truth, so help you God.
I do.
And is your first name George?
It's George Alexander.
We have it spelled with Ricards, last name Ricards.
Correct.
I just ask that you respond honestly and out loud. So it has to be verbal response to whatever questions are asked of you by both Ms. Schmidt or Mr. Wolven or me.
Understood.
Okay, thank you. Your turn, Ms. Schmidt.
Mr. Ricards, on April 9, 2010, did you enter into a land contract with Ms. Flannery?
Correct.
And what was the original selling price of that home?
$36,400.
What was the monthly payment to be? And did these payments include principal, interest, and taxes?
Yes,
And what was the term of this contract?
20 years.
Has Ms. Flannery made timely payments per the land contract?
No,
Since the start of the contract, how many payments has she made?
39.
And when was Ms. Flannery's last payment?
March of 2014.
Was there a forfeiture provision in the land contract for failure to pay the required payments?
Yes,
And Your
For
Honor,
some reason, and I'm not sure why, we're having a little bit of an audio with you, Ms. Schmidt, where it cuts part of the word off.
okay,
I don't know if it's fast or what. I mean, I've heard everything that Mr. Ricards has said, so we don't have to start over. But like, for instance, when you started April and you gave a date of 2010, we couldn't hear the date. The land contract was April 20-something?
April 29th of
Okay.
2010.
Yeah, so just every once in a while it goes blank. Are you getting that, Amanda? Yes. Yeah, so
Okay.
just try to speak. I don't know how close you are to your microphone.
All right, I
What?
will get closer.
That's fine, go ahead. So your
Uh,
last question was 39 payments have been made by her, the last one March of 2014.
correct.
And was there a forfeiture provision in the land contract for failure to pay the required payments?
Yes,
And Your Honor, that would be on page 3 of the land contract that was attached to the documents that were filed with the court.
Okay,
At the time of filing, how much was Ms. Flannery in arrears, the principal and interest under the land contract?
$23,788.48.
And how have you calculated that number?
Her payment of the 301.12 times 79 months due.
And that would be what, principal and interest only, not the taxes then?
Right,
Right, who has been paying the taxes on the home?
I have.
And was she responsible to do so under the land contract?
Yes.
And did she do so?
No.
And to date, what have you actually paid in the taxes?
$7,811.52
Where was the tax bill being sent?
to her.
So she would have had personal knowledge of the tax bill?
Correct.
And how did you know she wasn't paying taxes?
I called the town
Right? Each year you've had to do this?
every year.
Who is to pay for insurance on the home?
She was.
Since she's owned the home, has she provided you proof of insurance?
Never.
So who's been paying for the insurance on the home?
I have.
And how much have you paid to insure the home?
$5,543.53.
And did the land contract provide for late fees?
Yes.
How much late fees has she incurred?
$1,189.74.
How is this calculated?
5% late fee.
So once again, how much has Ms. Flannery paid on the land contract?
$18,200.
And did you keep logs of these payments?
Yes.
And these payments once again included principal, interest, and taxes.
Correct.
Have you ever sent Ms. Flannery notices or statements requesting payment?
I have, yes.
Can you recall the date of the last notice or the last statement requesting
It would
payment?
have been probably March of 2015.
Other than this action, have you ever filed another action against Ms. Flannery for failure to make payment on the land contract?
Yes.
And what year was that?
2011.
And what was the result of the 2011 court action?
Paid $7,700.
So what'd you do, dismiss the case then?
Yes. On the day of the case.
You testified that Ms. Flannery's last payment was in March of 2014, is that correct?
Yes.
Why have you waited until February of this year to retain me to file this case?
Well, it's, the attorneys eat up the amount of, money that we make on the house, and I felt it was a waste of time to keep suing her, and I figured at some point she'd start making her payments or send me a payoff.
Has there ever been an occasion where you verbally promised Ms. Flannery that you would give her the house free and clear?
Absolutely not.
Is there any written contract where you forgave the land contract balance, giving her the house free and clear?
Absolutely not.
So you agree that you had a relationship with her? That you had an affair with her?
A tryst? Yes.
Okay, when was that? What year?
2010,
And how long did it last?
3 months.
So it hasn't been a long term, it wasn't long term?
Absolutely not.
And since 2010 of August, have you had any other kind of contact with Ms. Flannery? So you haven't had an affair during that period of time?
I didn't get that length of time of the relationship or when it broke up.
Could you repeat?
3 months.
3 months back in 2010.
Thank you.
Go ahead, Ms. Schmidt.
Okay, so currently is there, how much is due and owing on the contract in arrears?
$31,600.
And there's $1,189.74 in late fees due and owing?
Correct.
And you paid an insurance $5,543.53?
Correct.
So that totals $38,333.27?
Correct.
Again, that broke up, Your Honor.
Yep. Okay, let's repeat the numbers again.
Okay, so I asked him, is there $1,189.74 due in late fees? And he said yes. I asked him that to repeat the insurance that he paid, $5,543.53. And I asked him if that totaled $38,333.27.
Okay, the next question.
I have no further questions, Your Honor.
Okay. Mr. Wolven, you'll be able to ask Mr. Ricards any questions that you have.
Thank you. Mr. Ricard, what was your employment or work in April of 2010
Same it is now. I work for Fox Ford.
Doing what?
I used vehicles for the car lot.
Did you draft the land contract? Did you draw the land contract?
No, I had it done.
I see. And you are aware of its terms, however, are you not?
Yes, the length, yes. In the rates, yes.
And you're familiar with the terms of payment?
Yes.
And those terms, as I recall, was based on a 20-year amortization, which came out to $400, correct? I'm sorry, I didn't hear that.
That is correct.
And that was translated in the language of the contract as $400 a month.
Correct.
And that actually comes out at an amortization of 8%. That comes out 20 years. And yet it was supposed to include the taxes also. Is that not true?
The payment did include $90 a month towards the property taxes, correct.
Where do you get that $90 a month?
The amount of the amortization was like $311, and she paid $400, which the balance went towards the taxes of the property.
But that's not stated in the contract. In fact, the contract, and let me ask you further, the contract says that the taxes will be computed annually. Could you tell me how that mathematically works out? How does that work?
I can't tell you how it works. I paid them.
Pardon?
I don't know how it works that she paid $400 a month, and the balance after the principal went towards the property taxes.
Where do you get that language? That's not in the contract.
Taxes included in payment of $400 per month to George Rickards. It's on line 6 of the contract.
In the land contract.
In the land contract.
You're reading a different contract than I am, because it says $400 and it says the interest will be paid and the balance on the principal. I don't see where you're getting taxes.
It
And
says
it says in the taxes are computed annually.
it's written right in here, right here on the contract. Taxes included in payment of $400 per month to George Rickards.
I understand it. I'm asking you how you compute that when it says taxes are computed annually.
I computed them figuring that would cover them, which it didn't, and I just paid the extra.
And I'm wondering also how this comes out at a 20-year amortization when the $400 takes up interest and principal alone. Mathematically, this thing doesn't work out.
Well, the company that prepared it used an amortization chart.
I understand, and they're correct for principal and interest. I have computed it and have it, and that's where we came up with the $8,000 balance. We were treating you as having made the payments, and without including any interest in there, it comes out to the 77. I don't have the exact figure, but 778. But let me go on. A couple of other questions I have. Who received the insurance bills?
I paid them. They came to me.
And also,
The insurance.
Excuse me. Did you have something?
She never provided home insurance to me. So I had a policy that I paid.
All right.
Check my investment.
On the taxes, didn't you also receive a copy of the tax bill?
No, I called the township, paid them, and then got a receipt.
Okay. Did you ever record this contract?
Yes.
Did you ever record a memorandum?
The contract's been recorded.
And your testimony is you never received a copy of the tax bill from the county, from the township?
From Sara?
You're testifying that you never received the tax bill from the township?
I never received a tax bill.
All right. Let me see, just a second. Did you have, after the termination of the relationship that you say went on for maybe 3 months, did you have any further contact with the defendant?
Never.
I have no further questions.
All right, Ms. Schmidt, can you think of any follow-up you have?
No, I have no follow-up questions.
When you're talking about Mr. Ricard's not having any contact with her after the relationship ended, my understanding was it was back in 2010. You call it a tryst. It was 3 months long, and yet you filed a lawsuit with her in 2011. True or not?
Yes. That is true, Your Honor.
But you never had contact with her during that lawsuit?
Absolutely not. It was all through an attorney.
Okay. And when you go back and you look at the payments that you received over the course of the last 10 years, sporadically at best,
Yes,
you received $18,200.
in total, correct.
And when you talk about in total, it's not separated from what the monthly payments are or what the late fees were or what the insurance was. You're just saying on the payments that you got, it was $18,200.
Correct.
Okay. How was it that you got to know Ms. Flannery in the first place?
Our children went to the same school, and we met her in about 2006.
And when you say we met her, are you talking about you and a spouse?
Yes, correct.
When you talked about the house itself, and the question was, why didn't you ever, beyond 2011, I think you said it was 2014 or 15 that you asked her to pay, you said something about the money we make on the house. It wasn't turning out to be a profit for you. You said the money we make on the house.
That's
Are you
incorrect.
talking about like an investment deal where you sell the house and then get more money for it?
Your Honor, what I was stating is that the attorney's fees we were trading them off for the amount of money we collected, so that's why we didn't sue her at that point.
Okay, and when you keep saying we, who is the other person? Your wife?
Yes, I talked to my wife about stuff. It's all me on paper, but yes,
Uh-huh.
I have.
And
Yes,
did you own this home in Sparta without your wife?
Yes.
Was it before you were married to that person?
No, Your Honor.
Are you still married to that person?
Yes, Your Honor.
But you had ownership of a house, this house in Sparta, and your spouse had nothing to do with it.
I bought that house in Sparta with the plans of reselling it to Miss Flannery.
Uh-huh. And when you had the land contract prepared, that was by somebody separately?
That title company do it.
Uh-huh. And your best reason to say why you haven't pursued it more, or why haven't you stayed on top of this, is because you just thought eventually she'd pay it.
Well, Your Honor, I knew I was protected by ownership of the house. And I knew as long as I paid the taxes and had insurance on it, I wasn't gonna lose it.
Okay.
I knew sooner or later, I figured I'd get my money.
Uh-huh. And while you're indicating that you never got any paperwork from her about the house being insured, you just automatically would insure it.
Of course.
And you wouldn't deal with her about it, you wouldn't talk to her about it.
I did not talk to her about it, and she never showed us insurance.
Well, you never talked to her about it, so she wouldn't have a reason to show you anything about insurance, would she?
Well, as an owner, she would be required to provide that to us. to me.
Not if you don't ask for it. You're never talking to her about it. You say you had absolutely no contact with her. So how do you know whether she had the house insured? I know you had it insured.
Well, that's a good question. I guess I
I mean,
don't.
you never asked her for proof of documentation of the house being insured. Is the same
You are
insurance
correct.
company that insured that house the same insurance company that insures your house you live in?
That insurance company's had that house since I bought it. So
And it's the same insurance company the whole time?
yes,
Okay. And in fact, when you would go to repay it for the year or get your bill, you never talked to her about it at all?
absolutely not.
Okay. All right. Any other questions you have, Mr. Wolven?
None.
All right. Ms. Schmidt, do you want to call another witness?
I have no further witnesses, Your Honor.
Okay. Mr. Wolven, do you want to call any witnesses?
Yes, I'd like to call the defendant, Your Honor.
All right. Ms. Flannery, can you raise your right hand if you please? You do solemnly swear you'll tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Can you adjust the camera on your computer? Because we're seeing like the top of your head to the ceiling. We're not seeing your face. Down a little bit more so we can see your face and you talking.
Let me put something underneath the, hold on
That
just a
would do
moment.
it, just like a book or something.
Yeah, hold on just a moment.
Because it's just pointing like your forehead and above.
Is that better?
A little bit more.
Let me get a bigger book. Hold on.
I'm not saying you're not talking, I get it, but it's just easier to watch you speak when we're listening to what you're saying. That's okay. Right there is good.
Is that better?
Yep, that's better. Okay, now you're under oath, and I just put you under oath to testify in this case. Speak out verbally. Mr. Wolven's going to ask you some questions first. Go ahead, Mr. Wolven.
Deb, the plaintiff has indicated that you had an affair for about 3 months. Is that true?
It started much earlier than that. It was a progression over a period of time, not just solely in 3 months.
How long did it last?
Well, there was holiday, there was time spent up at his cottage, it would have been.
Ms. Flannery, we're not wanting the details. We just want to know how long.
I'm
He
just-
said
I'm
3
just
months,
working-
you're saying what?
It's
1 year, 2 years, 3 years, 4 years?
yeah, it would have
whatever.
been over. It would have been over. It would have been over a year. It would have been an accumulation of time and progression. Would have been. It would have been close to 2 years.
Did he ever ask you to pay the taxes?
Did he communicate that with me outside the
Yes.
contract? No.
Did he ever ask you to pay insurance?
Outside the contract, from Al, no.
He has alleged that you've made about $18,000 worth of payments. Is that true?
I guess I would have to see it. I don't recall. I don't recall getting any court ordered information or a court case.
I'm not
We're
sure.
not talking about whether you ever got any court things. We're asking you, how much have you paid on this land contract over the years? Did you ever keep track of it? Did you not keep track of it?
I did not.
Uh-huh.
But
Do you
have-
know if you paid anything?
If so, it would have been very minimal.
Uh-huh. Go ahead, Mr. Wolven.
Gotta think here a minute. You've indicated to me and to the court that you feel that you do owe something. Is that correct?
That would be correct. Yes, sir.
And I think you've also indicated to me that this has basically been your home for 10 years,
That is correct. Yes, sir.
and it's your desire that you want to keep this home.
That is correct. My children and I would like to remain in the home.
And I think you've also indicated to me that, should we call it deep embarrassment about what's happened?
Yes, it's been very shameful. It's been like wearing a scarlet letter. That is correct.
And I think you've also indicated to me that you feel that you have been misled or deceived. Is that correct?
We had some very intimate conversations that would suggest something greater than a tryst. That would be correct.
Did you ever expect or realize or that you had to make payment on this land contract?
Yes, I think at some point in time, yes.
Your Honor, I've got my phone going off somewhere and I can't find it to shut it off.
We can hear it a little bit, but it's not too
Yeah.
much of a
Oh, I
problem.
found it,
Just take care of it.
Sorry about that.
That's fine.
It's off.
That's fine.
You and I've had a considerable talk in terms of what you owe, and you have read my brief that I've submitted to the court,
Correct.
and you and I computed the balance if you took the $400 a month and applied it to principal and interest, did we not?
Correct.
And that was, as I recall, 7,700, something of that nature.
Yes.
Is that correct?
Correct.
And you feel that whether because of charity or because of your affair, that he was not expecting payment for those months. Is that correct in your feeling?
Yes, there were some conversation to that. Yes.
And so that you feel that you should pay for the 9 months from February 11 that you owe for those payments. Is that correct?
That's correct. And I have put those in an account. That's correct.
And in fact, you have voluntarily been making those payments into a bank account and more in addition.
In addition, yes,
and
correct.
You realize that you should have the obligation to pay the insurance and to pay the taxes from that February 3rd date.
Correct.
And had you ever received any other notice or demands from the plaintiff for payment on the land contract?
Not to my knowledge.
I have no further questions.
All right, Ms. Schmidt, do you want to ask anything else?
I do. It's flattering. You had sent to my office a letter, and in that letter, did you state that you had not conducted yourself in a way pursuant to the contractual terms?
That is correct. I did say that.
All right, thank you. Did you also say that you neglected your responsibilities?
Yes, I was bearing the weight of the burden of the relationship for both of us. Correct.
Did you all, have you been diagnosed with clinical depression?
I have been diagnosed. Yes.
And in this letter, did you state that you agreed that it was $32,789?
Before seeking legal counsel, and I was going on the advice of a therapist.
Yes or no, ma'am? I'm asking yes or no. Did you say in this letter that you?
I did, yes, prior to counsel.
Right, thank you.
Yes.
Did you also say, and you used the words, a ballpark of 40,000 is due and owing, adding in attorney's fees and other stuff here?
Prior to seeking counsel, that is correct.
Okay. And is it typically your understanding that if you have an affair with someone, you expect for services rendered?
I'm sorry, I didn't get that, Your Honor, it's breaking up.
Can you
do you
repeat the question?
Yeah, do you typically expect large gifts for services rendered, ma'am? I mean, a house for an affair?
Well, Al was the only affair that I had. So do I typically request it or require that? I have no experience in that area.
So you believe that it's fair that the court waive all payments to date and that you only start paying on the house from February on?
I think coming to a fair and equitable resolution where we assume both responsibility, that would be my thought.
Do you have any proof that this affair lasted 2 years? Other than your testimony, other witnesses?
In what regard? Al created a separate email, so his wife would not be able to have access to that. He also got a telephone number.
And my question, I had a direct question was, what proof do you have this affair lasted 2 years?
The progression and the affair lasted 2 years. I don't chronicle that.
So did you and your family have, were you friends with him and his wife, and your children were friends from school?
I met Al through in the hallway at the kids' school. That is correct.
Okay, so you and your family and the kids knew each other, correct?
That is correct.
But you're saying that your friendship lasted 2 years or the affair?
I'm going to say that the start of the being Al was flirtatious and making comments. He would.
When did the actual sexual part of this affair begin? Not just talking and flirting or we're friends, because that could be misconstrued.
Right. Are you talking being intimate in terms of being touchy-feely? Are you being terms of other?
My direct question was, how long did you and Mr. Ricards have a sexual relationship?
Longer than 6 months, closer probably to a year or longer.
And once again, you believe that because of a 6-month or a year relationship, you should get to live for free for 10 years.
The conversations that Al and I had were intimate in nature, and he had entertained, what a relationship together and what our children would look like. And
so, yes or no? Do you believe that that the court should waive 10 years worth of payments because of an affair for 6 months or a year? I understand. Looking for a yes or no, ma'am.
I think reaching a equitable and shared responsibility would be where my answer would lie.
What does that mean? Yeah, I mean, so you're saying the court should waive 10 years worth of payments, yes or no?
Then I am going to say yes.
And you do not, you testified moments ago that you do not recall if you made any payments or how much they were. You have no recollection.
I don't have I have a vague recollection of contact in the beginning.
And you said that you don't keep track of any payments.
I was not at that time keeping track of any payments, no.
But you agree that you owe something, you said.
That would be correct.
And are you being treated for any kind of mental illness at the Christian Health Center?
I am being it would not call it mental illness. I am being treated for anxiety due to an autoimmune disorder called Hashimoto's, which causes edema and urticaria, and it has.
Were you mentally competent to sign this contract in April of 2010?
Yes.
Okay. You understood its terms?
I didn't read the terms. Al quickly went over and said, sign here and sign here.
Did you
And
sign it in front of a title company?
not to my knowledge.
Did you prepare it?
Did I prepare the contract? No, ma'am.
Okay. And so you stated, you just testified that you believe $7,700 is due and owing. Can you explain to the court how you came to $7,700?
That is something that my attorney had amortized with an accountant and come up with a number, and that is what we had put forth.
So you understand your payments were $400 a month?
Correct. With taxes and insurance.
But yet you believe you are only due and owing right now $7,700.
Based on the legal advice, that is correct. Yes, ma'am.
Okay. And do you have anything in writing rescinding this contract for cards?
Do I have what? I'm sorry.
Do you have anything in writing rescinding this contract for Mr. Rickards?
In writing, no. That is no.
Okay, so you have no written document saying you own this house free and clear, you don't owe me any more money.
That is correct.
Yet in a letter, so I guess I'm confused. When you wrote me the letter, were you lying then or are you lying now? Because in this letter, you state that you owe in a ballpark of $40,000.
That was before that I spoke with legal counsel, and I was assuming full responsibility for a relationship that we had. And
Right, thank you. I have no further questions. Thank you.
What's the date of the letter you're referring to, Ms. Schmidt?
February 28th of 2020.
Okay, that's fine. Mr. Wolven, do you want to follow up with any other questions that you want to ask?
Not with
Flannery?
respect to the defendant, but I do with respect to the plaintiff.
Okay. We've already had Mr. Rickards on the stand, and he's testified both direct and indirect. You're indicating you want to call him again.
Yes,
I would object to that, Your Honor.
I can tell you why, Your Honor. It's in support of the testimony of the defendant with respect to two confidential telephone numbers that were in existence for a considerable number of time between the
Well, you
two of them
guys-
only.
You guys, I'm not Oprah, and I'm not Dr. Phil. And in all due respect, I'm not getting into, I think I allowed way more information. You talk about mental health problems, I'm sure Mr. Rickards has his share, as all of us do. And we could get into a lot of things about how long they were intimate, or when they met, or how they knew who, or who felt shame. I'm not here about that. And I don't want to get into it. I don't want to get into if they had secret numbers or secret names or what they did. They got to live with that. I don't even want to get into it. I said at the onset, it's a bit of a unique case because of the circumstances that surrounded it. And not just how the land contract was executed, but how it was dealt with over these last 10 years. That's as unique as well. Maybe the fact that they were in a relationship makes more sense that it was so slack or casual. But I'm not going to spend my afternoon taking testimony on whether they had a 3-month relationship, a 3-year relationship, or a 30-year relationship. That's not really helping me. So if there's another part, Mr. Wolven, that you want to inquire, Ms. Schmidt is objecting to him being a witness again since he already was a witness for both direct and cross-examination.
I withdraw the request, Your Honor.
All right, that's fine.
I do
Do
like
you
like to
have-
make a summary, though. quick.
Do you have any other witnesses at this time, Mr. Wolven?
I do not.
All right. And Ms. Schmidt, you have any rebuttal witnesses?
Not, Your Honor.
All right, then I'll let you both make your arguments. We'll start with the plaintiff because they brought the case. Ms. Schmidt will be able to speak. I've taken notes. I've been listening. Then I'll let Mr. Wolven speak. And then I'll let Ms. Schmidt have the last say as the party that has the burden. Go ahead, Ms. Schmidt.
I'll just keep this very simple. You know, once again, I'll restate that we believe that what was currently due and owing at the time of filing was $23,788.48. That my client has paid the taxes and insurance, with the taxes being $7,811.52. And with the insurance having been $55.43.53. The late fees were $11,089.74. I'm sorry, $1,189.74. We would once again restate that there was a court action in 2011 where she did pay $7,700. And so the total here due and owing today, rearage, would be $38,333.27. And that would be calculated on, once again, on 79 payments of $400 a month. We believe the land contract was appropriately drafted. The parties understood it and signed it, and it should be upheld. Thank you.
All right. Mr. Wolven, go ahead and make your argument if you please.
Yes, Your Honor. This thing that's first heard before the court said, well, what's possible explanation for this long time of the plaintiff not bringing action? Well, the testimony indicates clearly what the reason is, either because of the affair, maybe because he's planning this as some kind of a long-term investment, or maybe the guy's just being kind. I'm not sure. But in any event, she has absolutely no reason to believe that this is going to be enforced. And what we have done is first, we took the amount owing on April 29th, and we applied $400 a month at 8% interest. And calculating that as though he were making the payments, there is a $7,788 balance. We have indicated some slight modification in that we've accepted their amount of the penalty, and we've basically come up with the $8,000 figure. I do have, though, and we have looked at this, and she has looked at this from the beginning with respect to, I'm embarrassed. I was involved in an affair, but it wasn't me alone. Is it the woman that has to bear the burden all the time? And in doing that, we have come up with 2 or 3 equitable solutions, which I think the court has the authority to do in view of the waiver and the equitable estoppel and the latches. The initial one would be the $8,249 that I think is the accurate amount, and it currently reflects exactly what has happened between these parties. There is a second possibility that could be involved, and that is if with the I gotta find my notes here. I don't have a desk in front of me, and that is simply 50% of the sale price. Just cut the 36 in 2. She has 90 days to redeem, and $18,000. And the final one, which I think would be totally unfair, would be to have an appraisal and have her have the authority to purchase it at 50% plus taxes and insurance from February 3rd. Certainly the law, considering the waiver and the estoppel, the case law, her lack of any information or knowledge and relying on the affair, we suggest that the amount should be $8,249 and with a 3-month redemption.
Okay, appreciate your courtesies. Ms. Schmidt, do you want to have any final say?
Once again, I would reiterate to the court that there is the, on that last page in the contract, it does state, talk about the lack of waiver. Didn't take action doesn't mean he waives any of his rights. It's right there in the land contract. I don't think we can dispute the language that's their own contract. Now he wants to dispute that. Trying to now say she can buy it at 50% if we have the house appraised and all this, that's just simply, there is no waiver and estoppel, Your Honor. I think that the land contract needs to be upheld.
All right, I appreciate your arguments. If you look at the plaintiff's complaint on this case from the very beginning, and I'm just doing it with my calculator right now. They were asking for $31,600 principal and interest under the land contract. In addition, they were adding on the taxes at $7,800, insurance at $6,100, and late fees at about $1,200, which comes up to about $46,782. This case has been, I've said it at the onset that it was unique. You know, not in a good way, but it is what it is and everybody has to deal with it. I've said before, I'm not Oprah or Dr. Phil, and I am not in a position to try to give thoughts about how bizarre this whole situation is. It is what it is. Parties have to deal with it. They were both adults. They both got themselves into this. Nobody had to sign that land contract back in 2010, but they chose to do that. I respect the fact that Ms. Flannery could say, I didn't really read it. You know, we didn't get into the details of what was going on in her life at the time. It sounds like both parties have kids. I don't know how old they are or how old they are now. But it's a difficult situation when people get themselves into a legal scenario when they haven't taken the time to look it over. But we do it all the time. People do it all the time. Even people like me do it when you're renting a car and you don't read every paragraph when you're getting your vacation rental car. You just want to sign on the dotted line and take off for the beach. You don't read every paragraph sitting there in the car dealership that you're renting the car from. It doesn't make an excuse. It's ignorant not to do it. It's ignorant not to be prepared or to read it, or to be recognizing there might be some things in the contract that you didn't look at. But this whole land contract is unique in the sense that it was conducted at a time when the parties were more than friends. They were going through a unique scenario, and somehow Mr. Ricards thought this would be a good way to make an investment, but didn't think it through, maybe thought it would be helpful, and there were benefits on the side. I'm not really clear what that all entailed, but no one took this on as a business arrangement. Nobody took this on as a transaction that was done from a real estate standpoint. This was all just very casual between these two people when they were going through something that, you know, they went through. You know, not something for either one of them to be proud of, but they chose to do this land contract. This isn't like trying to get into a business to buy a house, fix it up, sell it again, and make money. I mean, that's not what you do on a land contract 10 years later. when you look at the casualness of it, and I was taking notes carefully to find out, you know, Mr. Ricard's, at first I thought she never paid anything on it. And then when you look through and hear Mr. Ricard's testimony about the 2011 land contract transaction that occurred in court to have her pay, and she paid some $7,000 or something. I didn't get the exact number, but, and then again in 2015, a reminder that, you know, you got to pay this. And the last payment was in March of 2014. And when you go through the numbers, Mr. Ricard says she paid $18,200 under the original land contract over those 10 years at different times, last payment 6 years ago. And then you ask Ms. Flannery, how much did you pay? No calculations, no bookkeeping, no documentation anywhere. Really sounds like she doesn't even believe it's that much, but never said a number, never said a figure. Very, very casual about Mr. Ricard's paying for the insurance, but never talking to Ms. Flannery about, did you have insurance? Did you not have insurance? Can you provide me documentation? And if you don't, I got to put it on it. It was automatic for him. It was an automatic. He just paid insurance every time on that house. Whether he talked to her, no, not about insurance. Ms. Flannery relied on these intimate conversations about dealing with family, dealing with kids, dealing with the future, how the future would unfold. She talks about it like these conversations somehow bolstered her legal position. Not so. If it would have bolstered your legal position, you'd want it all in writing. You'd want another contract. You'd want something to protect you. If you honestly had the thought that I'll be taken care of, I don't have to do anything. Ms. Flannery testifies about my kids and I would like to keep this house. My children and I would like to keep the home. Well, of course you want to keep the house. You've lived there 10 years. But there's more to it that goes with keeping the house. If you follow up with your end of the financial arrangements, it is your house. That's what a land contract is set up to do. Over a period of time, to give you time to pay it. And like anything else, you're paying more than what the amount is. Because now you're paying interest, you're paying taxes, you're paying insurance, yada, yada, yada. Ching, ching, ching. It gets to be expensive. There's no question about it. And it's not just the $36,000. But your calculations with Mr. Wolven, as respectful as I can be, I mean, you're just coming up with numbers to try to make it workable for you. I mean, in essence, the calculations, albeit correct, from the way you guys do the calculations, gives you $400 payments without the proof of those payments. So just give credit for 92 months of payments when technically there were not those payments. I don't think either one of you thought this out very well. And without sounding ironic or bizarre, you didn't think through the whole thing very well. But I don't want to get into the Oprah Dr. Phil thing. My point is, if you're going to go into this as a business transaction and you're going to have a land contract signed, I mean, people that get married have a prenuptial agreement, not because they know for sure they're going to get divorced on the day they're getting married, mostly if it's a second marriage or whatever, but they want to have certain things protected in case. What was the reason to even do the land contract? There would have been no reason to do the land contract if you weren't going to try to hold up your end of the responsibilities. Why even do it if you could live there for free? No harm, no foul. We have cases all the time where it's, you know, a parent letting an adult child keep living at the house. They don't pay rent. You know, hold on a second. Whose dog is that?
That's
mine.
mine. Sorry, my
Okay, that's
son is
fine. I
coming
just
home
don't
from
want to have it.
school.
That's fine. I just don't want it to be a problem. So, I mean, you got to look at it for what it is in the bigger picture. And yes, if we all had this to do differently, we would do it differently. Clearly, we would do it differently. I mean, hopefully you do a lot of things differently, but I'm just talking about the financial transaction of the land contract. What I've done in making my decision, I am not trying to say that I know it all. I'm not trying to say I'm an expert at anything. I'm not saying that I'm the best one. I'm just listening to all this evidence and I'm making my decision. And what I did as it relates to making the decision is I'm trying to apply a land contract transaction without all the drama that you have caused by the uniqueness of why this even started. I'm not getting into all that, even though, yes, everybody's mentioned it. I'm going back and I take the $36,000 purchase price and I subtract the $18,200 that Mr. Ricards agrees that she had paid. I take that $17,800 and I add the $78,152, which is the taxes, and I take the $55,4353, which is the insurance. I do not add late fees. Discretionary decision of the court, took them right out. Mr. Ricards could have filed this in 2012, 13, 14, 15, 16, 17, 18, 19, and then filed it in 20. I think it's a bit disingenuous on a number of levels, but the land contract speaks for itself, and while some would argue the late fees could be added, $1,158, whatever it was, I didn't commit it to memory, I took it right off. Which means that the total that Ms. Flannery is going to have to pay in order to keep the house is $31,155.05. That includes the taxes, that includes the insurance, and that includes the strict amount of balance due on the original principal from the $36,000 with $18,200 paid. Because less than 50% of the purchase price is paid, it's a 90-day redemption period. And the 90-day redemption period starts today. 90 days, for lack of a better way to say it, is 3 months. Whether you have help, family, grandma, parents, siblings, bank, credit union, or whether you don't, Ms. Flannery, if you don't pay that entire amount at the end of that 90-day period, the house reverts back to Mr. Ricards. You and your kids would physically have to vacate the property. You would not own the home. You don't own the home now. The only way you'll get to own the home is if you pay that figure in 90 days. Now, I get that both sides can disagree, or it's not as much as what was originally being asked for, or it didn't calculate the numbers accurately, but I'm trying to go by what I heard through the testimony presented, which again, I say the big word for me is casual. Extremely, extremely casual how both of you handled the business aspect of this transaction. But in all due respect, It wasn't a business transaction. But you both got into it, and you both signed it, and you both made it a business transaction. Okay, now questions that you have, Ms. Schmidt?
I have none, Your Honor.
I want you to prepare the order on this.
Thank you.
Do you have questions, Mr. Wolven?
None.
All right. When attorneys are involved, I usually just talk to the attorneys directly to ask about questions instead of going through with the client. So I don't ask you, Mr. Ricards, and I don't ask you, Ms. Flannery. But if either one of you did have follow-up questions, I would suggest you talk directly with your attorneys for any follow-up, because I'm not going to have you address them with me directly. What happens from now is the judgment will enter, but I want the date of the 90 days to start right now. Whether I sign that a week from now or whatever, the 90 days is starting right now today. Okay, that's it, everybody. Thank you for your courtesies. I appreciate it. I know that there was effort made by everybody prior to this day to get it resolved. Okay, it didn't, but it is now. I do think there's some benefit to having this resolved. However it's going to end up, I don't know right now. But move on in a positive way. And the reason that I interjected when people are starting to talk about who's going to see a therapist or who's not, well, believe me, we all need to. And to point out one person and say, wow, they're having this, is completely unacceptable in my opinion. Okay, that's it. Thank you, everybody. We're adjourned.
Thank you, Judge.